The Financial Sector Conduct Authority has concluded its investigations into Stephanus Johannes Grobler relating to the financial statements of Steinhoff International Holdings for the 2014, 2015 and 2016 financial years, as well as the 2017 half year. The investigation found that Mr. Grobler contravened sections 81A, 81.1b, as well as the Financial Markets Act number 19 of 2012. These provisions prohibit the direct or indirect making or publication of false, misleading or deceptive statements. The financial statements issued by Steinhoff during the relevant period were found to be false, misleading and deceptive in respect of material facts that were either misstated or omitted. Grobler has been fined an administrative penalty of 358,750,000 rand. Well, let's unpack this further now with independent analyst as well as chartered accountant Khaya Sithole. Khaya, what exactly is Grobler being accused of having done?
Good evening, and good evening to the viewers. So essentially, Mr. Grobler was one of the chief enablers of the great heist at Steinhoff. So what he had as a role was that he was the general counsel, so he signed off on all the legal documents, and was also a director on some of the companies that were used to essentially perpetrate the fraud that was conducted at Steinhoff. So when the investigations obviously centered in on all the transactions, his name emerged as a constant and a common thread out there, and that is why the FSCA then said, look, actually, you've got a case to answer.
Why was it not enough for the chief legal to say, I'm not an accountant, I don't prepare the books, I'm not the auditors, I'm not responsible for auditing these things, I can't be held liable for it?
Well, simply because his name and his signature was on all the key documents, because naturally the auditors and the accountants essentially come after the fact. Somebody has to put together a structure, somebody has to create some super vehicle that is then created or at least meant to look like it's conducting particular transactions. So because of his cross-cutting role as the legal figurehead and also someone who was a director in these entities, his name kept showing up. And what that meant is that he couldn't plead ignorance. He couldn't say that, well, actually, it was the accountants that did it. Because the question was, well, the accountants wouldn't have been able to do it if he hadn't given them some idea that this was a legal, a legitimate entity that had entered into particular transactions. And of course, it was those transactions that were discovered to be shams.
Yeah, we'll get back to the details around what was wrong for those transactions, because I think it's important to reinscribe into the public memory exactly what those transactions were. But let's talk about the ongoing work that's being done to hold accountable those who were implicit and complicit in the great heist of Steinhoff, which of course eroded pension fund money, which are South African pensioners, right? Importantly, Khaya, does this absolve him of any criminal investigation and or prosecution?
No. So what happens is that the JSE and the Financial Sector Conduct Authority undertake their own investigations, and they obviously have to apply the rules that every single director or someone in a position of responsibility signs up for when they take on that particular responsibility. So they run their own processes, and all they can do is levy fines and issue, debarment orders. So in the case of Marcus Euster, for example, and all the other individuals of his cabal, you then hear about these lengthy periods in which they are not allowed to serve as directors of any other entity. So these particular entities only can do so much. They can only institute that particular level of punishment. The NPA, on the other hand, does have much greater latitude. And obviously, we do know that the former CFO is already in prison. And Marcus Euster, obviously, just before he was meant to appear in court, decided to end his life. So it is actually a process that runs in parallel. But the FSCA and the JSE in particular, really their main instrument and their ultimate instrument is simply the question of monetary fines and the banning from participating as a director or as a person of influential authority within a company.
Yeah. What other investigations and or prosecutions are currently still underway pertaining to those who were involved? Other than, of course, the former CFOs already in prison.
Well, we do know that the NPA already has cases pending against Stephanus Johannes Grobler and Louis Schreiber in particular. And of course, what we then have to wait and see is when they make their subsequent court appearances, what exactly is the nature of the case that the NPA is putting them. I suspect that on the case of what the FSCA and the JSE in particular are able to do, we probably have exhausted all the remedies available to them. And this is probably one of the last big outstanding numbers. And again, that fine is quite large. I mean, 360 million rand is not the type of amount of money that you and I have in the bank account on an ordinary basis. So it is quite punitive. And we do also know that in relation to the company itself, those particular sanctions have already been finalized and payments have been made. Yeah. And the interesting thing about them is that one of the great conundrums that you face when you're dealing with such white-collar crimes is a simple question of whether you want to punish the company and the shareholders who were innocent, who were unaware of what was going on, particularly when the perpetrators already left the company. So if you look at the fines that were initially cited against Steinhoff, the company, versus what they ultimately paid, it was to acknowledge the fact that, well, actually, if you impose these fines, you are punishing those that still decided to support the company even after the chaos or the crisis had been discovered.
Khaya, just very lastly, we know that FSCA fines and penalties are reviewable, and what we've seen very specifically, fines and penalties issued by the FSCA in the Steinhoff matter had been overturned by court and revised downwards in the past. What's the likelihood that this fine, more than 350 million rand, will stand legal scrutiny and will remain as a hefty figure?
Well, the fine itself is not the issue. It's the question of whether the mitigating, arguments that are presented on behalf of the one who's been accused are sufficient enough for all of these appeal tribunals to say perhaps the number should be different. So there isn't a case that says that the FSCA is wrong. There could be a question that says that, well, perhaps in considering the spectrum of circumstances, the FSCA could have been more lenient, and that is really what that appeal process would be. Naturally, no one in their right minds wants to pay 360 million rand in relation to anything. So we expect that there will indeed be an appeal process, and it will be at that particular point in time where the FSCA has to be very clear and explain exactly what the basis for them making this calculation and levying the fine is. And then there will be an opportunity for the accused to then say, well, actually, in relation to this particular case, here are the factors that I think ought to have been considered or should have been given greater weight in the ultimate determination of what the sanction is. So that's just naturally how these things tend to work before a settlement is ultimately reached.
Yeah, thank you very much for wearing that Orlando Pirates t-shirt. You are an honorable man, Khaya Sithole. Thank you so much for that analysis. Khaya Sithole is a financial sector analyst and a chartered accountant talking to us there on the latest action taken by the Financial Sector Conduct Authority on one of the former executives of Steinhoff, issued a fine in excess of 350 million rand for the role he played in the great heist of Steinhoff.